scheduling a pretrial February 14th. And this is in regard to case B124588121, August 25th, 2021. No dog license. Same date, time, and location for B124582221, August 25th, 2021. Failed to vaccinate dog against rabies and or provide proof of vaccination. 3 additional matters, one at a time. State your full name, Mr. Durham.
Renzo of the family Durham.
Chair. For waive formal reading and their plea of not guilty. Mr. Durham, the court scheduling a pretrial date on this matter via Zoom. You must attend February the 27th, 8:30 a.m., 36th District Court in front of Judge Bryant. Understood? Very serious non-assaultive allegation, Mr. Durham, and the court has concerns that you missed a court date on this matter, as well as 2 other matters that we're about to handle. And your capious history, Mr. Durham, tells the court you do not listen to the court as ordered to appear, and that's concerning. Where if the court were to release you on another personal bond, sir, you treat it as you have in the past and disregard court's orders and simply not appear. And that's unacceptable, Mr. Durham. You must appear as ordered. So the court, based on your capious history, take into consideration the information presented by counsel, including that limit to employment status as relates to the ability to post bond, the nature of the charge, as well as the information alleged in the investigator's report, is setting, based on your capious history, is going to continue the bond set by Judge Bryant of 110%. Is that an affordable bond?
It's not.
Okay, so on that matter, the court is setting an
All right, welcome back, because today's clip is a masterclass in sovereign citizen self-destruction. If you've ever wondered what happens when internet law meets a real courtroom, this is it. We're dealing with Carlos, of the Durham family, a repeat offender in the genre of I don't recognize your authority, but please don't lock me up. This man has ignored court orders, skipped hearings, racked up bench warrants, and still believes that saying the right magic words will override reality. What makes this case special isn't just the nonsense, it's the multiple failures to appear. Multiple chances. Escalating bond conditions. And yet Carlos walks in declaring he's an executor of an estate, refusing to give a real name, and insisting he doesn't drive, he travels. Meanwhile, the judge is done playing legal whack-a-mole. This is where patience runs out and consequences kick in. Watch how every sovereign citizen talking point gets methodically neutralized. Watch how words stop working.
During this bond, you are not to purchase or possess a firearm or any dangerous weapon, and you are not to drive any motor vehicle unless you have a valid driver's license. Is that understood?
I don't drive, Your Honor. I travel. I'm not driving ever again in life. I travel, so I don't.
There's no traveling behind a motor vehicle. I'm not arguing with you, Mr. Durham. Excuse me?
I've already read the Supreme Court case law. I have a right to travel, sir.
Okay, well, I have a right to impose bond and conditions of bond, Mr. Durham, and I'm telling you, whether you call it traveling or driving, there's to be none of that behind a motor vehicle. You're not to travel if you're operating a motor vehicle or drive. No driving or operating of a motor vehicle, regardless of what you call it. Understood, Mr. Durham? No driving or traveling if you're the operator. Is that clear? And you're not to leave the state of Michigan. Is that understood?
I heard you.
And that's no driving, period. That's regardless of your license status. There's to be absolutely no driving.
Right out of the gate, we're in classic sovereign citizen territory. Notice how Carlos refuses to give a standard full name and instead introduces himself as Carlos of the Durham family. This isn't harmless phrasing, it's a deliberate tactic pulled straight from online forums. The belief is that refusing to identify yourself as a legal person somehow strips the court of authority. Spoiler, it doesn't. Courts don't require poetic self-identification. They require identity, and when you're already in custody on a bench warrant, that identity is not exactly a mystery. The irony here is thick. Carlos wants to be treated as separate from the legal system, yet he's relying on legal concepts like executor and estate to justify his presence. You don't get to cherry-pick legitimacy. Either the system applies, or it doesn't, and if it didn't, he wouldn't be standing there in cuffs.
Or traveling. Okay, I said no traveling either.
Driving is up.
No traveling. Just put that as a no traveling.
But that means I can't even go to court if I can't travel. I can't leave my house.
It's via Zoom. It's via Zoom. It's via Zoom. No traveling. The court dates are via Zoom. No traveling unless court ordered.
That's a violation of my rights. And I will appeal this in a higher court.
Did you want to address his traveling, counsel?
I'm sorry.
Did you want to address his argument that he can't, that he can travel?
He's going to comply with court orders.
And that means no driving and no traveling. Is that correct, counsel? No traveling unless court ordered. Yes, I can't leave the state of Michigan, and he cannot. Would he drive or travel? Which my understanding is him operating any motor vehicles. That understood?
And here's the part Carlos seems determined to ignore: this is not his first rodeo. He didn't just forget one court date. He ignored previous orders, skipped hearings, and forced the court to escalate. A bench warrant isn't punishment, it's enforcement. Courts only issue them when someone proves they won't show up voluntarily. This is crucial context, because everything that follows flows from this history. Judges don't tighten restrictions because they're annoyed, they do it because past behavior predicts future behavior. When you repeatedly demonstrate that court orders mean nothing to you, the court responds by removing your options. At this point, Carlos isn't being mistreated. He's being managed.
Very serious allegations. Again, you have a capious history on this matter. The bond was set by the judge when you failed to appear. You have a number of capious histories on this matter. It looks like you were originally given a personal bond, then you failed to appear on about September 1st of 2022, given a 10,000 cash surety, and then you failed to appear again December 14th of 2022, and then a judge will give you another 10,000 cash surety. I, as a magistrate, as counsel stated, have no. One moment, I'll let you address the court. One moment, Mr. Durham. Have no authority to amend the capious bond as set by the judge for your failure to appear. So for that reason, the bond is going to be continued as set by the judge of December 14, 2022 in the amount of $10,000 cash surety. During this bond, you are not to purchase or possess a firearm or any other dangerous weapon. No driving, no traveling unless court ordered. You will be fit with the GPS tether under house arrest if you're able to make bond. And no use of any alcohol or illegal controlled substance. Is there anything further, counsel?
I would respectfully ask the court to reconsider the GPS tether, Your Honor.
He's missed court on every matter before the court this morning, so no.
Thank you.
You're welcome.
No, I haven't.
Anything?
I done came to court a couple times on Zoom, on a tether. I done been to court.
But not all of the times it does not appear, Mr. Durham. It looks like you've missed court more than once on that matter that we just handled. Anything else on this matter, counsel?
On account of the county jail. I missed court on account of the county jail. They wouldn't take me to court. I missed court because of the county jail would not take me to court.
This exchange may sound simple, but it's legally loaded. When the judge asks, "Do you understand?" she's not asking whether Carlos can hear her. She's creating a clear record. Courts are meticulous about this because defendants love to claim later that they were confused, misled, or unaware. Carlos's history of ignoring orders is exactly why the judge slows things down and spells everything out. This isn't condescension, it's precision. The court is removing every possible excuse before tightening restrictions. And notice how the tone shifts. The judge isn't debating philosophy. She's assessing risk. Someone who repeatedly fails to appear becomes a flight risk, regardless of how minor the original charges were.
Concerns, sir, that you've had a capious on this matter as well as the matters before the court previously, and that demonstrates to the court that you failed to appear as ordered, and that's concerning regarding your intention to appear and handle this matter. It looks like you're on a personal bond by the Honorable Magistrate Ramsey Heath, where you failed to appear on or about December 14, 2022, and a bond was issued at 10,000 cash surety. I, as a magistrate, have no authority to change that bond as set by the judge. So the bond is going to be continued, taking into consideration any employment status presented by counsel as it relates to ability to post bond, as well as your capious history. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any other dangerous weapon. If you're able to make bond, you will be under house arrest, fit with a GPS tether prior to release. There's to be no driving, And no traveling?
This is where belief collides with math. Carlos asks whether a bond is affordable, and the answer matters, because bond isn't about punishment. It's about ensuring compliance. The court explicitly considers employment status, history, and prior failures to appear. That's the formula. And Carlos fails every part of it. Sovereign citizens love to talk about rights, but they rarely acknowledge responsibilities. Bond increases aren't arbitrary. They're the result of repeated non-compliance. If you skip court on a personal bond, the court escalates. Skip again, it escalates further. At some point, the system stops trusting you, not because of ideology, but because of data.
As well, you're getting an unaffordable bond redetermination hearing on January the 19th, 2023. Judge Sabri at the 36th District Court via Zoom. Do you have any questions or statements, Mr. Durham?
Yes, I do. This question is to
Go
you,
ahead.
the magistrate. Are you honoring your oath?
Before you say anything.
This is your turn.
Everything you say right now kind of will be live, we're on YouTube. Please do not say anything right here. I would like to actually, because I try to protect you, okay?
That was your attorney speaking and giving you I don't know what type of question that is, Mr. Durham. Do you have your counsel has indicated you have a right to remain?
Now you don't know what it means. You took an oath to uphold the Constitution, didn't you? Are you honoring
I don't
your
know
oath?
what the purpose. I don't know what the purpose. I'm not here to answer your questions. I can tell you that, Mr. Durham, as far as regarding questions that don't have anything to do with the arraignment. I'm not here to just answer random general questions that have nothing to do with your arraignment, Mr. Durham. So if you have any questions regarding your arraignment or your court date, you can please let me know.
I want to know who you are. You won't tell me your name. You won't tell me if you're bonded. You're a public official. Are you bonded?
Mr. Durham, I'm not going through. Mr. Durham, I'm not going through that. The nature of my employment.
You got to give me your bonding information, name, address, and your policy number so I can make sure you're adequately insured. Just in case you want to violate my rights, I got to make sure you're adequately insured. Are you a public official and are you insured?
My name is Chief Magistrate Jeffrey Courtroom. I've answered that question regarding binding, Mr. Durham. That's not something that's going to be addressed today.
So you're not going to put that on the record?
I'm just not entertaining a question that makes no sense during the arraignment, sir.
Yes, the infamous, traveling, not driving, argument. This is one of the most recycled sovereign citizen talking points on the internet, and it fails every single time. Operating a motor vehicle on public roads is regulated, no matter what verb you prefer. Calling it travel doesn't exempt you from licensing requirements. Hat makes this moment satisfying is how the judge adapts. She doesn't argue semantics. She simply removes them.
As indicated by statute. Mr. Durham, I'm not getting back and forth. Counsel, do you have anything further with Mr. Durham?
Number of the bonding company. Can I have any of that so I can contact them? I got to be able to contact them.
No, Mr. Durham, I'm not. I gave you, I let you know I was bonded. My name is Chief Magistrate Koperick at the 36th District Court. That's the information. Okay, counsel, we can try anything further. Mr. Durham, I've said more than once, we're not going through that here today on the record. So, Mr. Durham, if you have any questions about your arraignment or court date, otherwise, we're through with the arraignment. Counsel, do you have anything further?
To give me the name of the bonding company.
Unless you have anything else, Mr. Durham.
No driving. No traveling. No operating a motor vehicle, period. This is judicial efficiency at its finest. When someone hides behind word games, the court responds with clarity. And suddenly, the magic words stop working. This is the death blow to Carlos's credibility. The judge lays out the timeline: personal bond granted, missed court. Cash bond imposed, M.